Joette Katz is the former Associate Justice of the Connecticut Supreme Court who participated in making the decision of Connecticut's same-sex marriage case, Kerrigan versus Commissioner of Public Health in 2008. She is formerly the Commissioner of the Connecticut Department of Children and Families. She's been an instructor at Yale Law School and Quinnipiac University School of Law. She is the co-author of the book Connecticut Criminal Case Law Handbook, A Practitioner's Guide, and has received a variety of awards and honors, including the Connecticut Women's Education Legal Fund's Maria Miller Stewart Award in '93, the National Organization for Women's Harriet Tubman Award in '93, Connecticut School of Law's Distinguished Graduate Award in 2000, and the list goes on and on. Michael Norco is the Associate Professor of Psychiatry at Yale School of Medicine, Director of Forensic Services in the Connecticut Department of Mental Health and Addiction Services, Deputy Editor of the American Journal of Psychiatry and Law, an MAR graduate of Yale Divinity School, and one of the forces behind this conference. We are privileged to have him with us today. Janet Peck and Carol Conklin are the two plaintiffs in Kerrigan versus Commissioner of Public Health. Janet Peck is a licensed professional counselor with private practice in individual, marital, and couples counseling, and has been active in Love Makes a Family and a member of the Stonewall Speakers Bureau. Carol Conklin, also a plaintiff in the Kerrigan decision, is an electrician with the Connecticut Department of Developmental Services, and also a past member of the Love Makes a Family Speakers Bureau. Janet and Carol have been together for 36 years. They have been married in the state of Connecticut for 2.5. And Lisa Cahill is a professor of theology at Boston College, author of a variety of books, including Sex, Gender, and Christian Ethics in 1996, and together with John Garvey and Frank Kennedy in 2006, Sexuality in the U.S. Catholic Church, Crisis and Renewal, the Church in the 21st Century. So we have the privilege of speaking and listening to folk talk about the Kerrigan decision from a variety of different point of views. I ask that you give them your attention and careful thought.
Morning. Thank you. Well, I have, because I understand that there aren't many lawyers in the room, and so I apologize if I use terms that are legal speak, but I think hopefully as I go through this, you'll have an understanding of some of the questions and considerations that were before the court in the Kerrigan decision. I just want to spend about 2 seconds talking about how we got to where we got in a 4-3 decision and the vicissitudes of life. And so when Professor Carlin talks about procedural issues and you can't really tell who's going to get to the gate first and what issue is going to be of concern most to the court and who the players are going to be, Kerrigan is a prime example of that. It was a 4-3 opinion, and the deciding vote was a member of the appellate court because the then Chief Justice, William Sullivan, removed himself from the case at the last minute. And for those of you who don't know, just Judge Luby Harper, who then actually replaced me on the Supreme Court when I went on to become the Commissioner of the Department of Children and Families, is an African-American gentleman who is from New Haven and who really saw Kerrigan as an issue of civil rights. So he was the deciding vote in a 4-3 opinion, and it's a classic example of you cannot know these things ahead of time. Things happen in life. Justice Sullivan took himself out of the mix at the last moment. No way to know how that case would have gone otherwise. So, and maybe over a few drinks I can... Hard to hear me? Okay. All right. But I I ended with a flip comment about maybe in my next life, and when I'm the only one still alive, I'll write my memoirs and share some other details. The first issue I want to talk about very briefly is what was the first issue before the court in the Kerrigan decision. The first thing we had to address was whether the claim was even cognizable, because the trial court had concluded it was not. Now, what does that mean? Well, there has to be a constitutionally cognizable injury or actionable harm for a court to get involved. And a cognizable constitutional claim arises when the government singles out a group for differential treatment. At the time, Connecticut had a statute that authorized civil unions, 46B38 AA et sec. And the trial court below in the Kerrigan case had concluded that the distinction between marriage and civil unions was merely one of nomenclature, because our civil union statute provided all the same rights as marriage. The court concluded that the legislature, and this part of the opinion was unanimous. Let me back down. I'm sorry, back up a moment. The trial court initially, because all cases have to work their way up through the system, and so this was the trial court decision I'm referring to now, had concluded that the legislature had subjected gay persons to exactly the equal rights and opportunities of married people, and so the difference really didn't matter. It was just simply an issue of terminology, nomenclature. When the Supreme Court got the case, we concluded that, in fact, that was not the case, that the legislature had indeed subjected gay persons to precisely the kind of differential treatment by creating a separate legal classification for same-sex couples who wish to have their relationships recognized under the law. Put differently, the civil union law entitled same-sex couples to all the rights as married couples except one, and that was the freedom to marry, a fundamental right. So in light of the long and undisputed history of invidious discrimination that gay persons had suffered, we determined that we could not minimize the plaintiff's assertion that the legislature, in establishing a statutory scheme consigning same-sex couples to civil unions, had relegated them to an inferior status, in essence, declaring them to be unworthy of the institution of marriage. In other words, and I quote from the opinion, by excluding same-sex couples from civil marriage, the state declared that it is legitimate to differentiate between their commitments and the commitments of heterosexual couples. The court rejected the trial court's conclusion that marriage and civil unions are separate but equal legal entities, and accordingly determined that there was a constitutionally cognizable injury. So that was the first part of the opinion. Now, the defendants had contended that the plaintiff's equal protection claim did not satisfy two threshold equal protection principles. Specifically, the defendants had contended, first, that same-sex couples are not similarly situated to opposite-sex couples, and second, that the classes enumerated in our state constitution, Article 1, Section 20, as amended, constitute an exclusive list of protected groups. When we examine the question of whether the plaintiffs were similarly situated for purposes of challenging the governmental action in question, the inquiry is not whether persons are similarly situated for all purposes, but whether they are similarly situated for purposes of the law that's being challenged. The defendants had asserted that the plaintiffs were not similarly situated to opposite-sex couples, thereby obviating the need for the court to engage in the equal protection analysis, and I quote, because the conduct they seek to engage in, marrying someone of the same sex, is fundamentally different from the conduct in which opposite-sex couples seek to engage, close quote. Needless to say, the majority disagreed, concluding, I quote, both same-sex and opposite-sex couples consist of pairs of individuals who wish to enter into a formal, legally binding, and officially recognized long-term family relationship that affords the same rights and privileges and imposes the same obligations and responsibilities. Under these circumstances, there's no question but that these two categories of individuals are sufficiently similar to bring into play equal protection principles. that require a court to determine whether distinctions between the two groups justify the unequal treatment." Close quote. As far as Article 1, Section 20 of the state constitution was concerned, we concluded that the list of persons protected was not exhaustive, and that even if it had been exhaustive as to suspect classification, it was not exhaustive as to quasi-suspect classification, and therefore the plaintiff's claim was not foreclosed by virtue of the fact that sexual orientation is not an enumerated classification under Article 1, Section 20 of the state constitution. Let me just tell you what that provision provides. Quote, "No person shall be denied the equal protection of the law, nor be subjected to segregation or discrimination in the exercise or employment of his or her civil or political rights because of religion, race, color, ancestry, national origin, sex, or physical or mental disability." So the question was that list exhaustive? And we concluded it wasn't, but even if it had been as to suspect classification, which is the highest classification, provided protection under the Constitution, it was not exhaustive as to quasi-suspect classification. So consequently, we deemed that the plaintiff's claim was not foreclosed under our state constitution. What is suspect classification? I'm going to get into that versus quasi-suspect classification in a moment. As I look around the room and there's sort of glazed eyes, I apologize. So, suspect classification is race, alienage, and national origin. Now, quasi-suspect classification, that's what we're going to be talking about next. The next step of the court's analysis was, after we concluded we had a legally cognizable claim, and the claim was going to survive in the sense that it's clear that there was a differentiation between the treatment, question became now, what level of scrutiny would the court provide to the class, and whether the state could demonstrate a significantly legitimate state interest in nevertheless precluding homosexuals from getting married. We concluded that gay persons are entitled to recognition as a quasi-suspect class for purposes, and by the way, Massachusetts did not go off on that. I think my recollection is we were the first court to examine this issue through that lens. So we concluded that gay persons are entitled to recognition as a quasi-suspect class for purposes of the equal protection provisions of the state constitution, and therefore laws discriminating against gay persons, such as our civil union law at issue, were subject to what we call immediate scrutiny. There's strict scrutiny, immediate scrutiny, and rational basis, depending upon the level of interest at stake. Rational basis being the lowest. So if a state enacts legislation that does not address anyone who's either in a quasi-suspect class or a suspect class, as I've defined, you get rational basis review, which essentially means that if the government can come up, whether the government articulates a rational basis or the court can consider and find one on its own, it will pass muster. Essentially, almost everything passes rational basis review, in my experience. And so it's very significant that the court afforded the class quasi-suspect status, entitling those persons before us to intermediate scrutiny. So this meant that the state had to establish that the different classification of gay persons and other similarly situated persons served important governmental objectives, and that the discriminatory laws in issue that were being employed were substantially related to the achievement of those objectives. And it failed to meet that burden, and so we ultimately struck the statute as unconstitutional. Before reaching that ultimate conclusion, we first concluded that although the same factors are relevant for the purposes of identifying both suspect and quasi-suspect classes, we apply those factors less stringently with respect to groups claiming quasi-suspect class, because the intermediate scrutiny applicable to a statutory classification that discriminates on the basis of quasi-suspect status is less rigorous or demanding than the strict scrutiny to which laws burdening a suspect class are subject. So first, we determined that gay persons had been subjected to and stigmatized by a long history of purposeful and invidious discrimination. Second, we determined that the characteristic that defines members of the group, namely attraction to persons of the same sex, bears no logical relationship to their ability to perform in or contribute to society, either in familial relations or otherwise as productive citizens. In fact, we recognize that all of our statutes that ban discrimination in every economic and social institution and activity, specifically, we recognize those statutes, specifically focusing on our adoption laws. Connecticut proudly had a long history of having statutes that allowed gays and lesbians to adopt. So far from not being able to contribute to society, either in familial relations or otherwise as productive citizens, we had embraced a whole statutory scheme that demonstrated quite the opposite. Third, regardless of whether a person's sexual orientation is immutable or can be altered, because the trait identifying members of the group is so central to their identity and could be altered only at the expense of significant damage to the individual's sense of self, gay persons are entitled to no less entitled to heightened protection than any other group that had been deemed to exhibit an immutable characteristic. Fourth, gay persons represent a distinct minority of the population, and although at the time of this decision they recently had made significant advances in obtaining equal treatment under the law and therefore were not politically powerless, they nevertheless had established, on the basis of pervasive and sustained nature of the discrimination that they had faced as a group, that there was a risk that discrimination would not be rectified sooner rather than later, merely by resorting to the democratic process. Now, in connection with that point, we highlighted the statement from the legislature, and this was really, I can tell you personally, for me, crucial. So we had a civil rights statute, and which technically is affording equal treatment, ostensibly was affording equal treatment, and was deemed to be a civil rights acknowledgement, recognition. Despite that, when the legislature passed, as part of a political deal, when the legislature passed the civil rights, the civil union legislation, it had a proviso, which I found so offensive that it demonstrated to me that the discrimination at issue was not going to be rectified sooner rather than later merely by resort to the democratic process, because in fact the democratic process had resulted in this legislation. So the opinion highlights the statement from the legislature that the gay rights law shall, quote, this is the civil union law at issue before us, quote, shall not be deemed or construed to mean the state of Connecticut condones homosexuality or bisexuality or any equivalent lifestyle. To authorize the promotion of homosexuality or bisexuality in educational institutions or require the teaching in educational institutions of homosexuality or bisexuality as an acceptable lifestyle, to authorize or permit the use of numerical goals or quotas or other types of affirmative action programs with respect to homosexuality or bisexuality in the administration or enforcement of the state's anti-discrimination laws, to authorize the recognition of or the right of marriage between persons of the same sex, or to establish sexual orientation as a specific and separate cultural classification in society. And that's what General Statutes 46A-81R provided. It was so offensive. By singling out same-sex relationships in this manner, now there's of course no other statutory disclaimer for opposite-sex relationships, but by doing what it did, the legislature effectively had proclaimed as a matter of state policy that same-sex relationships are disfavored. That policy, which was unprecedented among the various anti-discrimination measures enacted in this state in all other areas, represented exactly the kind of state-sponsored disapproval of same-sex relationships, and consequently, I believe, served to undermine the legitimacy of homosexual relationships. It perpetuated the feelings of personal inferiority and inadequacy among gay persons, and it diminished the effect of the laws barring discrimination against gay persons. and indeed the purposeful description of homosexuality as a lifestyle, not condoned by the state, to me further stigmatized gay persons and equated their identity with conduct that was disfavored by the state. And so although the legislature eventually enacted that law, its enactment was preceded by nearly a decade of numerous failed attempts at passage. Finally, when we applied this heightened scrutiny standard that I articulated earlier, we noted significantly that the defendants in the case expressly had disavowed any claim that the legislative decision to create a separate legal framework for committed same-sex couples was motivated by the belief that the preservation of marriage as a heterosexual institution is in the best interest of children, or that prohibiting same-sex couples from marrying promotes responsible heterosexual procreation, two reasons that had often been relied on in states in defending statutory provisions that had barred same-sex marriage, against claims that those provisions do not even pass the rational basis review, specifically the Hernandez case in New York. And instead, in Connecticut, the defendant's sole contention was that the legislature has a compelling interest in retaining the term marriage to describe the legal union of a man and a woman because, in its claim, the definition of marriage has always existed in Connecticut and continues to represent the common understanding of marriage in almost all states in the country. Needless to say, we rejected that argument, concluding that tradition alone is never sufficient to discriminate against a protected class. And I'm proud to say that you have the Kerrigan decision as a result of that analysis. Thank you.
So my place on this panel is to represent one of the voices from the Pews. On October 10th, 2008, the Connecticut Supreme Court announced its decision in Kerrigan v. Commissioner of Public Health. That court, as we have just heard, concluded that the state impermissibly discriminated against individuals on the basis of sexual orientation by not permitting same-sex couples to be married, thus legalizing marriage for same-sex couples. We will hear shortly from one of the 8 couples who were party to that lawsuit. In responding to what it called the, quote, severe and sustained discrimination, close quote, against gay persons, and to the, quote, long-standing intolerance, close quote, of intimate homosexual conduct in our culture, the court was, in my view, making a statement about social justice. It was a statement that resonated with my perception of Catholic teaching, and I was gratified to learn of the decision through the media. That same day, the Connecticut Catholic Conference, the Public Policy and Advocacy Office of the Catholic Bishops in Connecticut, released its response to the Kerrigan decision on its website. The heading declared, in bold letters, Connecticut Catholic Conference, on behalf of the Catholic bishops, clergy, religious, and laity of the state of Connecticut, condemns today's Connecticut Supreme Court decision on same-sex marriage, with marriage in quotation marks, calls for a yes vote on a constitutional convention. Before going any further, I must note that the language of condemnation is not unleashed without powerful emotional effect, as you can tell right now. And I was stunned, perhaps naively, by the use of that language. After several paragraphs decrying the, quote, terribly regrettable exercise in judicial activism, unquote, and an intriguing criticism that the Supreme Court had, quote, chosen to ignore the will of the people, close quote, by imposing, quote, imposing a social experiment on the people of our state, close quote, the statement concludes with this argument. The real battle in this court case was not about rights, but about conferring and enforcing social acceptance of a particular lifestyle, a lifestyle many people of faith and advocates of the natural law refuse to accept. This ruling creates an inevitable conflict between people of faith, the natural law, and the authority of the state, close quote. Finally, the statement called upon Catholic people to vote in favor of a constitutional convention with the clear hope that a public referendum would overturn the decision. So let me try to unpack my reaction to this statement from the bishops. First, the statement was made on my behalf, condemning a civil judicial decision characterized by inclusion and acceptance of my neighbors. To me, that statement thereby corresponds to a message of exclusion and intolerance made on my behalf. I don't recall being consulted on this proposed condemnation made in my name. There were no deliberations, no opportunities for comment or contribution, and had there been such an opportunity, I most certainly would not have approved this message. Moreover, I know many other members of the laity, religious, and clergy who also would not have approved this message. Yet the statement was made with the implication of universal Catholic solidarity on the matter. In fact, when it comes to considering the will of the people, we have to note that Catholics have been out in front of every other religious group in their support of same-sex marriage or civil union, with a clear majority now favoring civil marriage for same-sex couples. It has been argued that this is related to the abiding reception among Catholics of the Church's teachings on social justice, and this is precisely the context in which I view these matters. At its heart, the Kerrigan decision acknowledged the reality that gay and lesbian couples fall in love and want to live in committed relationships in which they wish to be treated like other people are treated. It is hard for me to understand how that amounts to a social experiment. Every major faith tradition in the world espouses some version of the Golden Rule. That's not experimental. And how can the Golden Rule possibly apply to some people but not to others? How could that possibly be? And then there was the lifestyle argument, presented as a bald stereotype, giving people of faith permission to engage in acts of intolerance and extrusion, and declaring that such attitudes were inevitable as a matter of faith and natural law. There are, of course, no data to support the lifestyle claim, and it is shocking to me that the Church would offer to legitimize the refusal to accept others as a matter of faith. In the weeks that followed, and leading up to the November elections, the Connecticut Catholic Conference aired television ads every night, featuring a woman standing in front of the state capitol building, urging us to vote in favor of a constitutional convention. By that action, the bishops were not just issuing a statement that troubled me, they were now committing significant financial resources to this troubling statement, while real human needs went unmet. Things had gone, in my opinion, from quite bad to quite a bit worse. So I started talking to people in the church. Was I missing something? Was I the only one so upset? I talked to priests, nuns, lay ministers, a Catholic scholar, and a canon lawyer. No one had anything to say that helped me make any more sense of this response from the church. No one disabused me of my reactions, though I was grateful for the opportunities to talk about them with thoughtful and learned Catholic people. In fact, during the discussion with the Catholic scholar, the suggestion was made that perhaps we ought to hold a conference to explore these issues and ask those questions. And 3 years later, here we are. In many of those discussions, I was encouraged to continue to seek answers to my concerns. Some weeks later, I wrote to the Connecticut Catholic Conference to ask where the funds were coming from to support the extensive media campaign aimed at reversing marriage for same-sex couples. I received no response. At that, I wasn't particularly surprised. Months went by, and my discussions continued. By the spring of 2009, I had decided that I would take seriously the messages from Vatican II about my responsibilities as a member of the laity, and I would raise my concerns to church leadership. I sent a letter to the conference and to each of the 5 bishops individually. I will now share with you the relevant portions of that letter, which represented my reaction to the bishop's response to the Kerrigan decision. First, I object to the October 10, 2008 statement of the CCC in response to the Kerrigan decision being made in my name. This is clearly an issue about which Connecticut citizens differ, including Catholics, and such a statement of intolerance and exclusion should not be made as if it represented the unambiguous view of all the clergy, religious, and laity. Perhaps the 5 bishops are unanimous in this view, but I doubt all the clergy are, and I know that the religious and laity are not. Jesus never preached intolerance or exclusion, and he opened his table and his mission to all who would follow him. His criticisms were instead aimed at those who cloaked themselves in the righteousness of their laws while forgetting to love their neighbor. I offer this concern in the spirit of disclosing my desires to my pastors with, quote, liberty and confidence, close quote, noting that it is the laity's, quote, special task, unquote, to engage in the temporal affairs of the world. And I noted that I was quoting there from the dogmatic constitution on the church. The body of civil rights enjoyed by groups of citizens is clearly such a temporal affair. As a husband, father, and psychiatrist, my place in the world brings me to see this matter from a far different perspective than that offered by the CCC. I accept the statement of the CCC that its views on this issue are not expressed in hatred, but these views illustrate a prejudice against gay and lesbian people. In the decree on the apostolate of the laity are instructed to foster, quote, the art of living fraternally and cooperating with others, close quote, and to recognize the work of the Spirit in all people of God. I cannot live fraternally with my gay and lesbian neighbors as a member of the church while the church promotes my neighbor's exclusion from a common good in civic life. The Council Fathers acknowledge that this role of the apostolate, quote, in the social milieu is so much the duty and responsibility of the laity that it can never be performed properly by others, close quote. I would therefore urge the CCC to refrain from such future statements and to seek instead ways in which the entire apostolate might work to examine this issue and hopefully to resolve it more adequately by our common deliberation. And such common deliberation is an activity to which we are also directed in that same document. That such inquiry should be informed by psychology, sociology, and other sciences of which the laity have special expertise is an important recognition formulated in the pastoral constitution on the church in the modern world. I have written to share my voice on these subjects in confidence and hope, as I am guided to do by Vatican II's important statements on the significant role of the laity in the church. I also write to offer to engage in future deliberations of these important civil matters within a fuller representation of the lay apostolate. I write hoping that the church will do more to educate the apostolate about its responsibilities under Vatican II and to manifest that teaching in the example of inviting true deliberations, professing the church's belief that the Spirit enlivens the thoughts and actions of the entire apostolate, the full assembly of the baptized. I would gladly serve toward these ends, bringing to the table my special expertise of more than 25 years as a physician, psychiatrist, and forensic psychiatrist, as well as my general expertise as a layperson engaged in the demands of family and fraternal life in the temporal world, and my modest experience as a student of the sacred sciences. I received no response to the letter from any of its recipients. Based on my discussions with my Catholic colleagues, I had also decided to send letters to the editor to 2 of our diocesan newspapers, offering a much abbreviated version of these ideas. One newspaper acknowledged receipt of my letter, neither published it. Shortly thereafter, after much contemplation, prayer, and discussion, my wife and I decided to become what I will call post-diocesan. This is at least one step short of being post-Catholic, a term gaining currency, which I see as referring to disaffected Catholics who have left the church, but not without some continued reference back to it. I think the term expresses not only separation, but also sadness and loss. For us, being post-diocesan means no longer contributing to the annual bishop's appeal. It means no longer belonging to a parish from which a portion of our donations would go to the diocese. We had been actively involved in parish activity, including as ministers of the Word and Eucharist. This loss is not insignificant to us. But thankfully, our current status also means continuing to enjoy worship and communion in non-diocesan Catholic communities. It also means continuing to financially support the social justice work of the Church through a variety of wonderful Catholic institutions. We have voted with our feet and with our wallets. But we are not without hope. If there were no room for hope about the Church, there would be no reason to engage this conversation today. No reason to work from within the institution or to contribute to its mission, and no reason to join in Catholic communion. It is the work of the entire body of Christ to see that the Church leads to the kingdom of God that Jesus preached. Canon Law 212, Section 3, tells us that it is the right and at times the duty of all the faithful to manifest their opinions to their pastors on matters of the common good, the dignity of persons, and the good of the Church. If we truly believe that the Spirit works through all of us, then the laity must accept that we are the most abundant vessel for the manifestations of the Spirit. And thus, it is our responsibility to be open to the inspiration and calling of the Spirit. This is why we are here today, in faith, in hope, in conversation, and in action. Jesus had nothing good to say about people of faith who viewed Samaritans as other. How can we, in faith, participate in the othering of our neighbors whom we are commanded to love? How can we fail to stand up and speak out and ask for more from our Church? Thank you for your faithful presence.
Oh boy, and I'm supposed to follow that. I can't even compose myself. I will also guarantee you I won't be saying any technical terms here, so I'm going to give your brain a rest. 36 years ago, Carol and I fell in love and began to share our lives together. For 33 of those years, we dreamed of getting married, but were denied what we saw as a very important civil right. 3 months after the Kerrigan decision came down, Carol and I got married on January 24th, 2009, in front of all our family and friends. It was a wonderful day, although it was January. I wasn't ever sure I wanted to get married in January, but we didn't really want to wait any longer. It was cold, crisp, but a beautiful sunny day. And it was truly a dream come true for us. I think Carol and I wanted to marry for the same reason everybody else wants to marry, because we loved each other. And that's what you do when you have that same kind of love that Carol and I shared. And we wanted to make that kind of public commitment that is celebrated and honored throughout the world. We wanted to walk in the footsteps of our parents, who really showed us the true meaning of marriage. Carol's parents were married 51 years before her mom died. They taught us that marriage is forever. Unfortunately, my mother died when I was very young, and I really don't remember her. But what I have is an old 16mm film taken on my parents' wedding day. It shows my mother smiling at my dad in such a way that never fails to touch my heart and bring tears to my eyes. It shows my dad really looking happier than I ever remember him being. It's as if my mother left me a message on this film to show me how important it is to bond in this very, very special way with the person you love. Carol is that person for me. She's the love of my life. Uh-oh. And the person I know I was meant to marry. Family members have told me of my father's love and commitment to my mother as he took care of her through a very long and difficult illness. The words, "in sickness and in health, till death do us part," had tremendous meaning to us both as we recited them as part of our vows on our wedding day. To us, marriage is not just the glue that holds two people together. It's the glue that holds entire families together, generation after generation. Before we could marry, we lived outside of that special family bonding. Now that we're married, we are a part of, rather than separate from, everyone else. And I feel as though I have carried out the message from my mother in that old film that has connected me to her in a way that would not be possible before that day. So marriage has special meaning to us, as it has very special meaning to everyone else. Also, as we got a little older, I started having some health issues. I had way too many major surgeries and medical treatments. And I ended up right here in New Haven, at Yale New Haven Hospital, having tumors removed from my liver. It was very, very life-threatening surgery, major surgery. Carol and I were both scared to death. And she had promised that she would be in my hospital room when I got out of recovery. Unfortunately, she wasn't. She was out in the hallway fighting with a staff nurse to get into my room. When the nurse asked who she was, Carol said she was my partner. And you know, the word partner has so many different meanings. It ends up meaning absolutely nothing at all. So Carol went on to say, well, we live together, we love each other, we're lesbians, which kind of gets a little personal in the middle of a hospital hallway. But it didn't matter what she said. The nurse said, well, you have to be family, and you don't qualify. We had been together 20 years at the time. I guess that wasn't quite long enough. And so Carol pulled out the power of attorney out of her back pocket and said, you know, we thought that it would protect us during these times. The nurse took a look at it, read it, said, well, this does say that you can make medical decisions on Janet's behalf, but it still doesn't say your family. Carol describes this experience as one of the most frustrating and upsetting moments in her life, and I can well imagine it must have been. Had we been married, she would have said, she is my spouse or my wife. She would have been automatically allowed into my hospital room, no more questions asked, and no proof required. It is this experience and many other experiences like these that led us to realize that we really did need the rights and protections of marriage. And that's what led us to becoming plaintiffs in the Kerrigan case. The word marriage has power in a way that no other word has. It has meaning to us in the same way that it has to everyone else. So we were very fortunate to become, or very honored to be plaintiff couples in the Kerrigan suit. But our fight is not over, and I must say, this is a very smart woman sitting to my left here. She was on the right side of that decision, and we are very grateful to her and everybody else on the court. But our fight isn't over, because we were allowed to get married in Connecticut, and we got married in the same way that everybody else gets married in Connecticut. But we still don't have the rights of protections and all the on a federal level that heterosexuals are automatically granted when they get married because of DOMA. And that is totally unfair and as President Obama has said, unconstitutional. I agree with him. And totally discriminated discriminating to our marriage. So that law must change. Early on in our relationship, Carol and I came out in all aspects of our lives, in our social circles, in our workplaces, and in our families, because we wanted people to see that we are just as human and we create just as loving and committed relationships as everyone else. I came out to my family within about 6 months of beginning my relationship with Carol. Now, in full disclosure, I was not raised into a Catholic family. I was born Episcopalian. And actually, my elder brother, in his young adult years, became a Mormon. Everybody, however, in my family who had lived long enough was at our wedding, including my eldest brother. He fully supports, and his whole family was with him also. He fully supports my right to marry and other same-sex couples' right to marry, because he recognizes that his religious belief should never infringe on anybody else's religious belief or practice, nor should his religious belief ever deny anyone their civil rights. He recognizes that his love for his wife is no different than what I share with Carol. Carol, however, was born into a Catholic family, and her story is a little bit different, and her coming out is a little bit different, especially in reference to her father. And she would like to share that story with you today. Thank you.
I was raised in an Irish Catholic family. My aunt was a nun, my uncle was a priest. My parents had 8 children. My dad went to Mass almost every day of his life. When Janet and I were first together, my father was transferred to Florida for work. Before they left, my dad found out I was lesbian. He didn't speak to me for about 6 years. That was a very difficult time for me. He would come up here on business trips and visit with my brother and would not call me. When I talked to my mother about this, she would say he was just too busy, but he wasn't too busy to golf with my brother. And when I went to visit down there, he was just very distant. After about 6 years, my mother and father came up for a visit together, and we were invited to my brother's house to have dinner with him. I asked my mother, "Were you staying there?" And she said, "No, we weren't invited." I said, "Well, you're invited to stay at our house." And so they came and stayed with us. That seemed to break the ice with my dad a bit. After that, whenever they came up, they always came and stayed with us, and we started being able to go down and see them more. I think this showed my dad that we were just really good, caring people, and he seemed to accept us better. Janet and I had a party for our 20th anniversary, and I invited my parents, who agreed to come. I didn't invite my aunt, the nun, because I wasn't sure how she'd take it at the party, but they invited her, and so she came also. She had a good time. Before the party, my mom and dad sat us down and said that they loved us both very much and would do anything for us. But they couldn't condone our relationship because their church was against it. I was happy they came to the party and said they loved us, but I was disappointed that they could not get beyond their religious beliefs and fully support our relationship. A few years after that, my mother developed breast cancer and was dying. I knew she didn't want to be in the hospital and would rather be home, so my eldest sister, Janet, and I went down and took care of her. It made my father very happy to have her home with him when she died, knowing that he wasn't able to take her home and take care of him herself. I know that he appreciated that we were able to do this for him. After my mom died, we realized that it took an awful lot out of him physically and mentally, and that he shouldn't be living alone. So my sister and I talked to him about who he would want to be near or live with. We gave him the choice of either to live in Florida, where most of my siblings lived, or to come and live with us. He decided to come and live with me and Janet. That was when I realized that my father had come a long way in his acceptance of me and my relationship with Janet. Soon after my father came to live with us, we became plaintiffs in the Kerrigan case. So I had to tell my dad about it. I wasn't sure how he'd react to this, but when I told him, he said, "Good luck. I think you should be able to get married because you have the same kind of relationship that your mother and I had." His only regret was that we would not be able to marry in the church. My only regret was that my mom and dad did not live long enough to be at our wedding. We were able to share some really wonderful times with my dad before he died. His acceptance of us was a great gift, and the time we had with him was very special. I think this is a good example of how someone who is so involved with a church that actively preaches against marriage equality can come to see what we are talking about and what we share as love. In closing, I just want to say that the Catholic Church was an important source of support for my father, but I think on this issue it failed him. Thank you.
I just want to say before I begin, responding to what Carol just said, I've had the same experience in my own family with, I have a cousin who's a lesbian or a sister who's divorced and living with her boyfriend for many years. And sometimes people cannot adjust their mental framework, but they live in a way that's different. And I think we have to accept that and be grateful for that. You know, I've seen that in my own dad, who's 96. So anyway. But nonetheless, we're here to help adjust everyone's mental framework, so I will proceed with that process. Okay, so I would like to talk about basically three things, and the first of them a little longer, and I'll try to be brief so we'll have time for some discussion. So the three things are, what is the purpose of marriage, or what's the definition of marriage from a Catholic point of view and then from our cultural point of view? The second issue would be what are Catholic attitudes toward gay and lesbian couples? And the third part is what is the role of the Catholic Church in speaking out about civil law? And I know Patty Jung will also be talking about some of these issues in her address this afternoon, so I'm just going to be pretty quick. Okay, so first of all, what is Catholic teaching on the nature and purpose of marriage? And I'm thinking here of a quote that was in the bishop's statement, the Connecticut bishop's statement following the Kerrigan case that you were citing, Michael. And they quoted the dissenting Judge Zarella, who said, the union of one man and one woman has its basis in biology. Okay, so that would be one sort of view of the definition of marriage. And the basis in biology has primarily to do with procreation of children by men and women. The majority opinion, though, that I have not read, but that you cited, Joette, said that it is discriminatory to see gay people as unworthy of the status of marriage. So that's a different view. What is marriage? I mean, there's a different view of what marriage is implicit in that, and that's what I want to develop. So I think that in Catholicism and in cultures generally, there's a development but also an ambivalence on what marriage really is, as focusing around two different purposes, not necessarily opposed, but different. And one would be procreation and the organization of intergenerational kinship networks. The other would be a union of two deeply committed individuals around their love and the public recognition of that love. Obviously, oftentimes these two things go together. But I think that historically, cross-culturally, and anthropologically, there's no question that marriage historically has had more to do with family, kinship, intergenerational connection and organization, and transmission of identity and property to heirs, especially within a patriarchal framework, than it has had with the personal relationship between married partners. And if we look at the Catholic tradition, not to go over the whole thing, but to just cite the 1917 Code of Canon Law, which was replaced in 83, but in 1917, it defined marriage as a contract in which each party gives and accepts a perpetual and exclusive right over the body for acts which are of themselves suitable for the generation of children. And love was not any necessary part of that contract. So it was defined in terms of procreation. Okay, in the modern period, that attitude or that definition has changed or is changing worldwide. Nevertheless, our North American and European portrayal of marriage, primarily in terms of love, romance, finding a soulmate, a lifetime partner, is still definitely a minority position. But I think most of us here would accept that, and it's generally accepted in U.S. culture. That is, marriage is about the love of the partners. So this morning, Michael Perry spoke of marriage as based on a deep personal relationship. Jan said when she got up and started her comments, you said, I fell in love and I wanted to celebrate this in a public commitment. You said, she's the love of my life. Okay, so I think to most of us, that's what is really key and basic. So there's been a shift in our mentality. Now, one point that I want to make is that if we keep this in a Catholic context, the Catholic Church has played a part in creating the shift, in fact, a big part. So we see the shift also occurring in Catholic teaching and among, in Catholic popular opinion. So just going back, for instance, to the 1930 encyclical of Pius XI called Casti Connubii. This is one of the first big landmarks of the changing view. It wasn't that he said procreation is not part of marriage, or not that it's even the primary purpose, but he also said, and this is a quote, that mutual love can in a very real sense be said to be the chief reason and purpose of marriage. If marriage is seen more widely as the blending of life as a whole and the mutual interchange and sharing thereof. Okay, in the 1983 Code of Canon Law, we have marriage redefined as a covenant, not a contract, by which a man and a woman establish between themselves a partnership of the whole of life, which is ordered by its nature to the good of spouses, mentioned first, and the procreation and education of offspring. At the Second Vatican Council, the Pastoral Constitution on the Church in the Modern World had actually already in the 60s described marriage as a communion of love and again an intimate partnership of life and love. Marriage is founded in a conjugal covenant of irrevocable personal consent. So marriage and marital love are still said to be ordained for the procreation of children, but, and again a quote from Vatican II, that does not make the other ends of marriage of less account, and marriage is not instituted solely for procreation. In more recent years, we look at the notorious encyclical Humanae Vitae, which banned artificial birth control. But one of the important things about it that we often overlook, and this is also a theme in the writings of John Paul II, is that the focus is really on marriage and especially sex as a mutual self-gift. And procreation is not eliminated, but we're told that the sexual act should be open to procreation. So it becomes of less key importance, I'd say, and especially Humanae Vitae justifies deliberately avoiding procreation. So procreation becomes gradually less important in Catholic teaching, and love and commitment become more and more central. And I think in the popular Catholic imagination, as in the imagination of most people in our culture, that primary and secondary status of love over procreation has become even more prominent. So let me just quote a study that came out last summer, a study conducted by the Public Religion Research Institute, which found that, in fact, Catholics are more supportive of gay and lesbian relationships than the general public. And Catholics are more supportive of gay and lesbian relationships than other Christian groups. So almost 3/4 of Catholics, 74%, support the legal recognition of either civil unions or gay marriage, and 60% are on record as favoring the adoption of children by gay couples. So one conclusion that then leads me to is that the bishops, although they are making clear public statements, are not having a significant effect on the opinion of the Catholic people, nor obviously on the law in most cases. So, wherever we want to go with that. Okay, so the first thing is about the changing consciousness of what marriage is, or a changing view of what marriage is, that has centered more and more on love as the key. And that is actually, I think, the basic condition or the premise of our wide acceptance today of gay unions, including the acceptance within Catholicism, even to a greater degree than among the public as a whole. And I think that is due in great part to the changing definition of marriage, even within the Catholic Church. Okay, so the second point that I want to make, and again, the next 2 points will be made much more briefly. An issue that has come up over the day, beginning with Michael Perry's address this morning, is the question of what interest the government or the law might have in restricting the access of gays to marriage. And the thing that to me just glaringly comes out from an ethical standpoint as well as legal, thinking of the quotation that Michael offered this morning from John Courtney Murray, the burden of proof would be on showing that there is a danger to the public order that is presented by gay marriages. Joette just said that your majority decision, or the opinion, found that, in fact, there's no evidence that gay couples or gay people can't function as good public citizens. Okay. In addition, there's so an argument that's often brought out by Catholics and others against the recognition of gay marriage, it's not so much about the individuals functioning, but that the institutionalization of same-sex unions will undermine or discourage heterosexual unions and permanency. And again, there is no evidence for that as far as I can see. I mean, the evidence is much more strongly, I would say, in favor of the hookup culture, heterosexual infidelity, especially male infidelity, and an ethos of no-fault divorce and serial monogamy. I'm not saying I would want to go back to forbidding divorce or condemning all those who divorce, but when we're up to a 50% divorce rate, we have a problem, and I don't think it's the fault of gay people. Okay. In addition, to quote another study that was done, this one was done on the basis of data from the Census Bureau and the Center for Disease Control. Of the 10 states with the lowest divorce states, 5 of those states are among the 9 that also permit same-sex marriage. Now, that doesn't mean that the legalization of same-sex marriage causes a lower divorce rate, but it shows that the two things can certainly coexist. Okay? So the argument that same-sex marriage undermines heterosexual unions, I think, is completely bogus and without any foundation in reality. The final point that I want to make, again, very briefly, even more briefly, is that whatever one's view of the morality of homosexual unions, the Catholic Church's position on their legality should stand or fall, as I think Michael Perry was also indicating this morning, with the impact of those unions on the public order. The Catholic Church does not oppose legal recognition of other types of marital unions that it would consider immoral, particularly remarriage after divorce. And why not? Because it is to the good of society and the public order to have those marriages and children that may be raised within those marriages come under the protection of the law and also be subject to the responsibilities of married couples under the law. So it would be to the disadvantage of society to deprive those unions of legal recognition. So I think for all of these reasons, not only is Catholic public opinion supportive of gay marriage, but I also fail to see why even on the bishop's own grounds, opposition is necessarily required. Thank you.
We still have some time for questions from the group, and I'm getting one handed to me now. So I want to start with a couple of questions for Joette Katz and for the panel in general. The first is, if you wouldn't mind, if you can say why Sullivan recused himself from the case. That's the first question in the legal sphere. And the second is what the panel's views in general might be about extending marriage equality through legislative debates and resolution, as in New York, in distinction to the courts. I'm not sure what if the question is whether one is better than the other, etc.
Okay. The question of recusal in general, judges recuse themselves for a whole variety of reasons. Can you all hear me? And generally speaking, when judges recuse themselves, they don't tell anyone why. They don't have to tell anyone why. I mean, we have, particularly when you're on the Supreme Court, you have an obligation. It's not like anyone can just fill in for you. It's not like on the trial bench, so it really is incumbent upon you to only do it for a certain, it can be an ethical situation. For example, if you're good friends with one of the litigants or the lawyers, it's your former firm, it's a former client. So those are reasons that are pretty apparent and pretty obvious. You could have a business interest that touches one of the lawyers or litigants in front of you. You also might have a similar case yourself that would cause a disqualification. But the reason you don't have to articulate it is because you don't want to chill the ability of a judge to do that. So hypothetically, if you have an inappropriate personal relationship with one of the lawyers or litigants, you can understand why you don't want to have to disclose the reason. And if you had to disclose the reason, then you wouldn't disclose and you wouldn't recuse. In this case, and normally this would not really be in the public domain, and I won't get too detailed about it, but just because it was noted in Massachusetts, and so it is out there. Then Chief Justice Sullivan had a conversation with a judge in Massachusetts about issues involving homosexuals. And as a consequence of that, he decided it was best to take himself off the case. And when that conversation he was reminded of that conversation, he thought it was prudent to remove himself. Does anyone else, do you want to talk about that?
You're the lawyer on the group.
So why is it better to come through a court than through the legislature? Well, I mean, ideally, you'd love these things, and people have different philosophies, and we were certainly accused of legislating from the bench. But I think, quite frankly, the reason I focused so long, and I apologize, on the civil union statute demonstrates why. Because that was a political compromise. It still didn't provide all the rights that marriage, if none other than to recognize the role that marriage plays in our society. And it also, it was, the word I want to say almost insulting, frankly. So there it is, it's bestowing a partial right, it's insufficient, and it's basically apologizing for doing it. I would love the will of the people to prevail more often than not. Certainly it would make the role of judges easier, but when that doesn't happen, then it is the responsibility of the court to step up to the plate when the case is properly brought before it. I mean, courts don't reach down. We're not in the business of looking for controversies to resolve, frankly. But when the will of the people, I mean, when you think back historically, you couldn't have an African American and a Caucasian marry. Now, is that something that the court should have said, well, you know, we'll wait another 100 years till that works itself out? I mean, so there really does come a certain point in time at which it is the role of the court, and that's what's beautiful about checks and balances and 3 branches of government. We all have our role to play.
There are a number of questions that the content of which will also apply in our later conversation, and given time I may hold a couple of them until then, but please know that your questions have been heard. There's a question here, why is the Catholic hierarchy's focus on understanding of marriage so focused on the pelvic zone to the exclusion of the whole body? Why all this focus on conjugal sex? And related to that, for Professor Cahill, is it possible for a Catholic theologian or ethicist to go beyond not opposing civil marriage for same-sex couples to argue for the sacramental marriage of couples in the Catholic Church, and how might that kind of argument be made?
Yeah, I mean, I'm not, is it on? Like, can I be heard or not, I guess? You're up. Yeah, thank you. Okay. I didn't quite get the part about the whole body and so on. I mean, one thing that comes to mind is that in the Catholic Church, certainly motherhood is a big deal. You know, those of us from the perspective of women's equality almost sometimes think that that's exaggerated, but it certainly goes beyond just the pelvic area to general relationships within marriage. Mm-hmm. So we might critique the way those relationships are construed, but I think there is a more holistic view, at least of the person and the body in marriage. In terms of sacramental marriage, in fact, the sacramental character of marriage for Catholics is not based on sex. So it would be pretty easy to argue that. A marriage comes into existence by virtue of the consent of the partners since the Middle Ages. So it's not because of sex and it's not because of procreation, it's through personal consent. And one of the biblical texts that's frequently cited to support the sacramental character of marriage is Ephesians 5, where the love of husband and wife is analogized to the love of Christ for the church. So the sign, the indissoluble love of the partners represents the love of Christ for the church, and that's its sacramental character. And we also find that in the tradition, you know, beginning with St. Augustine in the 4th century, that it's the indissoluble bond that provides the basis of the sacramental character. So I think it would be easy to argue, you know, looking at certain grounds, the question would be, well, why the opposition? Mm-hmm. And I think it is because of this, you know, remaining understanding of marriage as about procreation and the organization of kin relationships within the patriarchal family. And that's not just in the Catholic Church. I mean, again, I would say that's probably the dominant understanding of marriage worldwide. It's not one that I subscribe to or that we probably do here, most of us. But that would be the history of it.
Great. Another question.
Hey, I'm sorry, can I?
Please.
I just want to
yes.
Add something to 2 questions ago, because I think it gets lost. Part of what the court is going through is deciding whether or not a group is politically powerless. And that's part of, so when you're looking at whether or not a court should decide an issue or the will of the people through the legislative process, that was part of the analysis. We looked back, I mean, we were comparing ourselves. It's not just numbers, because the United States Supreme Court in the case Frontiero which was giving women the status of putting them under the quasi-suspect categorization. It wasn't just about numbers, because they were in the majority, but the question was, how many senators were there? How many congresswomen? how many governors, what role have women traditionally been able to rise to in 1973 when the case was decided? That was part of the analysis here, and why we looked and said, you know, although certainly more and more people are coming out, are they nevertheless politically equal? Are they politically powerful enough to get their rights through the legislative process? And because they had not been able to, despite major strides in a whole variety of areas, because they had not been able to, that was part of the equation. So when you decide that someone is politically powerless, that's another reason why the court would give them status and then conversely look at the government's restriction to decide whether or not it was legally proper. So, I'm sorry.
Not at all. Not at all. Another question. There's a precedence for a small but vocal minority to declare something in the name of the church, but it's not opposed in order to preserve the illusion of unity, and a couple of examples are given. So this questioner wonders whether the overall lack of response to a letter like yours, Mike's, might be an effort to preserve a false illusion of unanimity in the CCC. So I wonder if we might just talk about silence for a moment. But talk about it.
But don't, right. Not demonstrate it. Right. I didn't, well, my own interpretation of the lack of response was not that it was an attempt to create an illusion of unanimity, but that it was that it felt possible to ignore a minority viewpoint or one person's viewpoint, and that's all was going on there, that they saw no reason to respond. There was no political agenda to respond to me. There was no need to respond to me. It wasn't going to hurt anyone in any way to ignore me. And so that's what happened. You know, and in a way, I don't want to sound like, you know, to offer some sort of narcissistic comment that how dare they not respond to me. But, you know, I thought that there were serious ideas expressed there that deserved some sort of response, and that didn't occur. And I thought that that was at the very least disappointing. But I didn't interpret it as an effort to maintain an illusion.
Yeah. Can I make a brief comment?
Lisa and Joette, please.
The issue, though, is it wasn't a minority, as I was just showing from this data. And so it's an unwillingness to really try to take the pulse of what the faithful believe and to engage with that. I mean, even if they think it's wrong, then they should realize they have a huge educational task before them. But instead, we just won't even look at that. That's the problem. You're not a minority.
As someone with a criminal defense background, their silence can be very dangerous, quite frankly, and there are instances in which it's deemed not only acquiescence but a tacit admission. So to me, when something rises to the level of a response and you don't respond, it's an admission, it's an acquiescence, it's an acceptance. So as someone who's, I want to say, I don't have a dog in that fight, as the only Jew on the panel. It was something that merited and deserved and in fact demanded a response. I will also say, as the person who's the only Jew on the panel, silence is dangerous.
Yeah.
It's, and as someone, frankly, who lost a significant portion of my family in the Holocaust, silence is dangerous. So I share your outrage.
I think it's appropriate to follow that set of points with this question, and to end this section with this question. The majority of Catholics support marriage equality. What is the role of the laity and theologians for that making that message be heard? to anyone who on the panel who wants to take it.
All right, I'll start, but then I'm going to throw it to Lisa. Well, I think part of the responsibility is being here. Part of the responsibility is talking to people in your parishes. Part of it is to raising objection when, the Knights of Columbus donate huge amounts of money to fight social equality. Right now they have a wonderful ad campaign about how they're helping children in Haiti with prostheses, but they're also still doing things that violate social justice. And I think if you know people who are members of the Knights of Columbus, you might call them out on that. So those are just some of the things, and the more of us that have those discussions, the less possible it is to ignore them. So I don't know what you want to say from a theological point of view.
I hope this isn't coming in from too off base of an angle, but again, I'm just so impressed by the fact that there isn't a great lack of support among Catholics for marriage equality. Like, they already support it, according to this data. And I sometimes get frustrated with the way in which Catholic opinion is equated with what the bishops may be saying publicly, including the public attention and the media attention that is given to it, which magnifies a voice which is not, in fact, representing what the voters may do in any election. So it's just like Paul Lakeland this afternoon is going to do a session on ecclesiology and the laity. And I think that's a huge issue for us as Catholics. We still sort of in a passive way almost allow Catholicism to be defined by the bishops. They do have a legitimate teaching and leadership role, and they exercise that well in some areas. But on this area, the followers are leading, not the bishops, if you know what I mean.